for motion for reconsideration of Judge Allen's October 27th, 2009 order granting Irene Perry's motion for summary judgment. D. January 28th, 2008, Ms. Perry was served with a complaint in ejectment and non-payment of rent, again giving her notice of Mrs. Gray's ownership of the rental property and request for her 1/3 share of the monthly rent. A true and correct copy of the complaint is appended hereto and incorporated herein by reference at Exhibit E. E. May 29, 2008, Ms. Perry signed a stipulation agreement to avoid eviction, in which she agreed to remit 1/3 of her monthly rent to Patricia Gray beginning June 1st, 2008. A true and correct copy of the stipulation agreement is appended hereto and incorporated herein by reference at Exhibit F. F. In a municipal court hearing December 8th, 2008, Patricia Gray versus Ingrid D. Johnson, Philadelphia Municipal Court, number S as in Sam, C as in Clarence, -07-08-03-3600, Ms. Perry, by way of her counsel, breached the stipulation agreement by telling the court the payments made to Mrs. Gray from June 2008 through December 2008 were not her 1/3 share of the rent, but garnishee payments made on behalf of Ingrid Johnson. This meant that Ms. Perry had not paid Mrs. Gray any rent from June 2008 through December 2008, as she had promised in the stipulation agreement to avoid eviction based on the default judgment entered against her in the ejectment action, Patricia Gray versus Irene Perry, Philadelphia County Court of Common Pleas, November term 2007, number 3237. One tenant in common, in this case Ingrid Johnson, cannot bind Patricia Gray to accept Miss Perry paying all of her rent to Ingrid Johnson. Penrose versus Penn Forest Coal Company, 289 PA 519. Additional citation 137 Atlantic, 1st edition, 670, 1927. When co-tenants join in a lease reserving a common rent payable to the lessors jointly, either of them may receive and give a valid receipt for the entire rent until notice by one or more of the co-tenants that that co-tenant's share must be paid to him or her. Emphasis added. Swint versus McCalmont Oil Company, 184 PA 202, 38 Atlantic, 1st edition, 1021. When several tenants in common appoint one of their number to collect the rents, one of the joint owners has a right, emphasis added, at any time to revoke the agency so far as his or her own interest is concerned, and after notice of such revocation, it is the duty of the lessee, emphasis added, to pay over to the revoking co-owner his or her proportionate share of rent. Barrett versus Bemelmans, 163 PA 122. Second citation 29 Atlantic, 1st edition, $756. There was never a need for a revocation in the case of Irene Perry, since she was on notice not to pay Mrs. Gray's 1/3 share of the rent to anyone but Mrs. Gray. A tenant in common may recover for injury to his or her interest in the common property, whatever it may be. Adams versus New Kensington, 374 PA 174, second citation 97, Atlantic second edition 354, 1953. If Miss Perry believes that she was misled, fraudulent misrepresentations made to her by Ingrid Johnson and or Louis Starkman Company, she has a remedy at law. However, she cannot live in a property and decide who should get the rent and what they have to do with the rent they receive, as her attorney, Mr. Weinberg, suggested at the Rule Returnable hearing October 27, 2009, before the Honorable Judge Allen. Mrs. Gray was within her legal rights to bring an ejectment action against Miss Perry. A tenant in common may maintain an action in ejectment against strangers, Miss Perry, who are in possession without joining other tenants in common. Fry versus Stetson, 176, PA Super, 171, second citation 106, Atlantic second edition 662, 1954. Two, did the trial court err in granting a summary judgment while there are issues to be resolved in the 10 new matter counterclaims against Irene Perry? Suggested answer, yes. The moving party plaintiff / counterclaim defendant Irene Perry bears the burden of proving that no genuine issues of material fact exist. The following 10 new matter counterclaims were filed against Ms. Perry. Ms. Perry did not address these counterclaims in her motion for summary judgment or at the Rule Returnable hearing on October 27, 2009. Therefore, the plaintiff / counterclaim defendant Irene Perry failed to meet her burden of proving no genuine issues of material fact exist with the new matter counterclaims. Those counterclaims are as follows. A. New matter counterclaim ejectment, non-payment of rent. B. New matter counterclaim loss of rental income. C. New matter counterclaim trespass. D. New matter counterclaim contractual interference. E. New matter counterclaim conspiracy. F. New matter counterclaim imposition of a constructive trust. G. New matter counterclaim replevant. H. New matter counterclaim unjust enrichment. I. New matter counterclaim negligence. J. New matter counterclaim fraudulent misrepresentation. A. New matter counterclaim ejectment non-payment of rent. An ejectment action furnishes one of the remedies by which a landlord may recover possession of real property from a tenant. Moser versus Granquist, 362 PA 302. Second citation 66, Atlantic second edition 267, 1949.